All right, today we're going to be going over presentation of offers, obligation, strategy, recourse, and ethics. Buyer's agents are frequently concerned that an offer delivered to a listing agent has not been presented to the seller. Concern is especially present in hot markets or when listing agents are acting as dual agents. Residential purchase agreement provides one solution in which a listing agent has an opportunity to confirm presentation of the offer or to have the seller reject the offer formally by initialing the bottom of the RPA. This, however, is not legally required. Regardless, presentation of all offers to the seller is a fundamental duty of the agent. This presentation discusses the requirements of presenting an offer, options to ensure an offer has been presented, and potential consequences of failing to present an offer. The obligation to present offers. Are there really listing agents who are intentionally not presenting offers? Unfortunately, there really are. However, the vast majority of listing agents abide by their fiduciary duty and the code of ethics and present all offers to the seller. When a buyer's agent is unsure that an offer has been seen by the seller, oftentimes the seller is overwhelmed with the number of offers received and is not signing every one. Or perhaps the seller is not, in fact, responding back to the listing agent. There is usually a reasonable explanation. Is there a legal or ethical requirement that the seller initial a rejection? Even though all of the car purchase agreements contain a space for rejection of offer to be initialed by the seller, there is no legal requirement that the seller initial it in order to make rejection effective. Doing so is merely a courtesy for the buyer and buyer's agent. There is no ethical requirement to initial a rejection since the seller, assuming that they are not a realtor, is not bound by NAR Code of Ethics. Is there a legal or ethical requirement that the listing agent initial the presentation of offer box? Legal requirement, no. Even though all of the car purchase agreements contain a space for presentation of offer to be initialed by the listing agent, there is no legal requirement that the agent initial it. Doing so is merely a courtesy for the buyer and buyer's agent. Ethical requirement. Through December 31st, 2018, no. There is no ethical requirement for the listing agent to initial the presentation of offer box. However, effective January 1st, 2019, the NAR Code of Ethics was amended. Specifically, Standard of Practice 1 through 7, as amended, states that a listing broker or agent is required to confirm in writing that an offer was submitted to the seller if the cooperating broker who submitted the offer so requests. The listing broker or agent must provide the written affirmative unless the seller has waived the obligation to have the offer presented. What are the general legal and ethical obligations that a listing agent has regarding presentation of offers? Legal duties. The common law imposes a fiduciary duty on real estate agents which restricts agents from gaining an advantage over their clients or putting clients' interests second to their own. Failing to present an offer is a clear violation of this duty and could constitute fraud, dishonest dealing, incompetence, or substantial misrepresentation, all of which may, in the real estate commissioner, suspending, delaying renewal, or permanently revoking an agent's real estate license at any time. Listing agent's failure to present an offer may also give rise to a direct legal claim by the seller. Since there is a fiduciary and confidential relationship between a seller and a listing agent, an agent's failure to disclose information relevant to the seller's decision may constitute negligence, breach of fiduciary duty, intentional interference with a prospective economic advantage / relations, or even constructive or actual fraud. Ethical duties. The ethical obligation to present all offers received from a buyer applies to all realtors nationwide. National Association of Realtors Code of Ethics require all realtors to present all offers and counteroffers as quickly as possible. This is Standards of Practice 1 through 6. Moreover, the Code of Ethics states that realtors have pledged to protect and promote the interest of their clients, which of course would include presentation of offers. Violations of an agent's fiduciary duty to present offers may also be grounds for disciplinary action under Code of Ethics or MLS rules. Disciplinary action under the Code of Ethics may include letters of warning or a reprimand, level 1, 2, or 3 fines of up to $15,000 based upon first or repeat offenses, the requirement to attend and complete education courses, cease and refrain orders, suspension, and expulsion. MLS rules. California Model MLS Rules 9.4, 9.5 further specify that the obligation to present all offers and counteroffers must be satisfied as quickly as possible. Is a listing agent bound to continue to present all offers even after an offer has been accepted? Yes, even if an offer has been accepted, listing agents are bound to present all offers until closing or the execution of the lease, unless expressly instructed otherwise by the seller landlord. NAR Code of Ethics 1 through 6. Are there any circumstances in which the listing agent is not obligated to present an offer? Yes, if the listing agent has been expressly instructed by the seller in writing not to present an offer, then the listing agent is not obligated to present the offer. Also Code of Ethics Standards of Practice 1 through 7. Does the listing agent have a duty to present even oral offers? Yes, the broker must disclose to the principal seller all offers that have been made by any person, whether an offer is writing or oral. Strategies to ensure the offer is presented. If it is unclear that the seller has been presented with the offer to purchase, can the buyer's agent simply call the seller and inquire directly? Typically, no. The NAR Code of Ethics requires that when a client is in an exclusive agreement with an agent, any dealing with that client must be carried through that client's agent or broker. However, directly contacting another agent's client is permissible if the agent or broker gives consent, if the contact is initiated by the client, for other reasons explained in the next question. What are the available options to ensure that the seller has seen the offer? The first step that any buyer's agent should take to ensure an offer has been presented is to contact or attempt to contact the listing agent. It is advised that the buyer's agent document each communication. The buyer's agent could ask that the seller initial the space for the rejection of the offer, or that the listing agent initial the space confirming the presentation of the offer. Beyond that, the buyer's agent should be careful, since their demands for proof of the presentation of the offer may mark that the agent as overly aggressive. Therefore, a buyer's agent should rely on their own judgment as to how strongly they communicate any demand for proof of presentation. With this caveat in mind, here are several options. The demand that offer be presented to seller letter. If communication is unsuccessful and the buyer's agent has a reasonable belief that the listing agent has failed to present the offer, the buyer's agent may send a demand that the offer be presented to seller letter, a letter DPO in the CAR sample letter library. The DPO is a formal request for confirmation that the offer has been presented and reminds the listing agent of the legal obligation and consequences of neglecting to present an offer. DPO can be found on the zip form website within the CAR sample letter library. Right to participate in the presentation of the offer to the seller under MLS Model Rule 9.6. When submitting an offer to a listing agent, the buyer's agent has an option under MLS Model Rule 9.6 to be present and participate in the presentation of the offer to the seller. However, the buyer's agent does not have the right to be present at any discussion or evaluation of that offer by the seller and the listing agent. To properly request participation, agents may use the request to participate in presentation of offer. This is sample letter form RPP. The RPP can be found on the zip form website within the CAR sample letter library. Under Model Rule 9.6, the seller also has the right to refuse the presence of another agent during an offer presentation if written instruction by the seller is given. However, if the seller demands this, the buyer's agent has a right to receive a copy of the seller's written instruction. Direct contact under Model Rule 9.1. The buyer's agent also has an option to contact the seller directly under the proper circumstances. Under the MLS model rules, negotiation directly between the buyer's agent and seller is permissible if the buyer's agent makes reasonable efforts to contact the listing agent and there's no contact from the listing agent for more than 1 day. CA model MLS rules 9.1. Since the local MLS rules may differ from the model MLS rules, buyer's agents should check their own MLS. Additionally, Model Rule 9.1 allows the listing agent to preclude this direct communication in all circumstances, so a buyer's agent must check for this as well. Contacting the listing broker. Nothing precludes a buyer's agent from contacting the listing broker. Obviously, a buyer's agent should use discretion in employing this tactic. No one likes to have complaints directed to their supervisor. Recourse for failure to present offers by the seller, buyer, and buyer's agent. What damages could a seller sue for if a listing agent does not present an offer? A listing agent who does not present an offer is typically liable for fraud or constructive fraud, which in some cases may allow for benefit of the bargain damages, depending on whether the agent's misrepresentation was intentional or merely negligent. Practically speaking, this means that the listing agent may forfeit the right to their commission. In addition, the agent may be liable to pay the difference between the price obtained and the price which might have been obtained. Breach of fiduciary duty may also result in the award of prejudgment interest, third-party attorney's fees, indemnification, and punitive damages against the agent. Lastly, if the agent received any secret profits or was unjustly enriched because of the transaction, the agent may be liable for the profit amount. Does the buyer have any legal recourse against the listing agent or listing broker? As a practical matter, a buyer likely has no specific legal recourse against a listing agent or listing broker who fails to present an offer. This is primarily due to the listing agent not having any fiduciary duty or existing contract with the buyer. However, it's possible for a buyer whose offer was not submitted to argue various violations of law. For example, the law requires the listing agent to diligently exercise reasonable skill and care in the performance of the agent's duties, and imposes a duty of good faith and fair dealing. These obligations extend even to non-fiduciary prospective buyer. The breach of such legal duties could give rise to a claim of unfair business practices. But still, how could the buyer be sure that the seller would have accepted the offer even if it had been presented? And how could one know if the escrow would have closed? In short, the challenge of proving causation and result damages is likely to be legally insurmountable. Additionally, the listing agent's conduct could be considered an intentional interference with a prospective economic advantage. But for such a claim, the intentional interference requires an existing economic relationship between the buyer and the seller. There is none in the case of an unsubmitted offer. A possible future relationship or lost opportunity does not suffice. Ultimately, the buyer's remedies are really to bring the agent's bad acts to light. The buyer may file a complaint with the local MLS, Department of Real Estate, or association for disciplinary action, but such actions will not result in financial compensation. Does a cooperating broker or buyer's agent have any legal recourse against the listing broker? Similar to buyers, a cooperating broker or buyer's agent would likely not have a specific legal recourse against the listing broker or listing agent who fails to submit an offer. There is a potential that the buyer's agent can claim that the listing agent breached an obligation to exhibit good faith and fair dealing With regard to their offer of compensation through the MLS, the legal argument is as follows. In every contract, there is an implied duty of good faith and fair dealing. The MLS unilateral offer of commission was accepted when the buyer's agent procured a ready, willing, and able buyer. The listing agent, by intentionally not presenting the offer, sabotaged their own unilateral offer of compensation and thereby breached the implied duty of good faith, fair dealing. Therefore, commission is due to the buyer's agent. However, this issue would be subject to binding MLS arbitration. Although it's possible for an MLS to decide in favor of a buyer's agent in this circumstance, the proof of wrongdoing would have to be overwhelming and the actions of the listing agent egregious. Even then, a decision in favor of the buyer's agent would be highly improbable. Perhaps if an MLS rejected arbitrating the issue because of the novelty of the legal theory, the cooperating broker could sue in court, where this technical legal argument would have a greater chance of success. So just as with the buyers themselves, the only likely recourse for buyers agents and cooperating brokers would be to file a complaint with the local MLS, Department of Real Estate, or Association Disciplinary Act. Code of Ethics Amendment 2019. Code of Ethics was amended to require that listing agents verify delivery of the offer in writing. To further assist buyers agents in assuring an offer has been presented, the National Association of Realtor Code of Ethics Standard Practice 1 through 7 was amended to reflect this concern. With the changes, a listing broker or agent is required to respond in writing that an offer was submitted to the seller if the cooperating broker who submitted the offer so requests. The listing broker or agent must respond in the affirmative unless the seller has provided written notification waiving the obligation to have the offer presented. This modification became effective January 1st, 2019. The exact language of the amendment to Standards of Practice 1.7 is as follows. Upon the written request of a cooperating broker who submits an offer to the listing broker shall provide a written affirmation to the cooperating broker stating that the offer has been submitted to the seller/landlord, or a written notification that the seller/landlord has waived the obligation to have their offer presented. This change in Code of Ethics was approved on May 19, 2018 by the NAR Board of Directors. Sample letter. Demand that offer be presented to seller. DPO can be located by signing into car.org and accessing zip forms. Once in zip forms, click the blue menu for all forms in the top right of the screen. Use the drop-down menu to limit your search to car sample letters. Scroll down to find demand that seller be presented to seller letter. Thanks for viewing. We have more training videos available in the online office. And as always, call, text, or email with any questions.